Welcome to Prep Solutions PHR Situational Judgment. Stay with me to the end. I have a gift for you. Here is the scenario. A 180-person boutique fashion retailer on the East Coast. 9 stores. No prior litigation history. Priscilla, the VP of Human Resources, is pulled into a Thursday strategy meeting by the new Chief Merchandising Officer, IKOS. The CMO wants a luxury cosmetics counter. He says the customers are women, so the staff should be women, and he has heard a BFOQ allows a women-only hiring policy for it. Priscilla knows BFOQ is a real Title VII concept. She also knows the answer the CMO wants is the wrong one. She pulls up the statute. She has to explain what a BFOQ actually is, cleanly, before the CMO pushes back. When does a BFOQ actually permit restrictive hiring under Title VII? Your 4 options. Option A. A protected characteristic is reasonably necessary to the normal operation of that particular enterprise. Option B. Customer preference dictates the use of a specific gender. Option C. Federal contractors must meet specific demographic utilization goals under Executive Order 11246. Option D. Providing a reasonable accommodation would create an undue hardship for the employer. Pause here. Pick your answer. Ready? 4 real employment law concepts. 3 of them sound plausible. Only one is the actual BFOQ test. The correct answer is option A. A protected characteristic is reasonably necessary to the normal operation of that particular enterprise. Title VII at 42 U.S.C. 2000E-2E defines the BFOQ exception in exactly that language. The standard is essence, not preference, not convenience. The Supreme Court has held this exception to an extraordinarily high standard for 60 years. The accepted examples are narrow. A male model for menswear. An actor cast for an authentic biographical role. So here is the line to keep. The BFOQ defense protects the essence of the business, not the comfort of the customer or the preference of the manager. Picture a massive stone wall. Weathered, carved, it fills the frame. Across the top, the carving reads, Title VII, no discrimination based on race, color, religion, sex, or national origin. The wall is enormous, and carved into it, low and center, is one single archway. A narrow Gothic arch, barely wider than a person. That is the BFOQ exception. Look at the size ratio. A vast wall, one tiny opening. The picture is the doctrine. Above the archway, 3 brass keys hang on a hook. Key 1, essence of the business. The characteristic must be central to what the business actually does. Key 2, factual basis. The employer needs evidence, not a stereotype, that all or substantially all of the excluded class cannot do the job. Key 3, no reasonable alternative. The job cannot be redesigned to remove the restriction. All 3 keys are required. 2 is not enough. Now look to the right. A smaller iron panel is embedded in the wall, chained shut and padlocked. The carving reads, race, color. Never a BFOQ, no key fits there. The statute permanently excludes race and color from the defense. 4 figures stand at the wall, each holding a request slip. Figure 1 walks through the archway. The slip reads, authentic acting role, essence. It passes. Figure 2 is blocked. The slip reads, customer prefers female staff. Preference is blocked. Figure 3 is blocked. The slip reads, affirmative action utilization goal. Wrong statute. A different door entirely. Figure 4 is blocked. The slip reads, undue hardship. Wrong statute. That is the ADA, not Title VII. The keyhole opens only when the characteristic is essential, not when it is convenient. There's a second layer, the statutory exclusion. Zoom in on the iron panel. Below it, a parchment unfurls. The actual statutory text from 42 U.S.C. 2000E-2E. It shall not be an unlawful employment practice for an employer to hire on the basis of religion, sex, or national origin, where that characteristic is a bona fide occupational qualification reasonably necessary to the normal operation of that particular business. Notice what is missing. Race is not in the list. Color is not in the list. 3 classes are listed: religion, sex, national origin. An authentic acting role can use sex. An Orthodox rabbi role can use religion. A diplomatic translator can use national origin. None of them can use race. Congress wrote it that way in 1964 and kept it that way. If a Title VII question mentions race or color and asks about a BFOQ, the answer is automatic. No defense exists. 4 moves. The EEOC BFOQ Defense Audit. Identify. Name the class the employer wants to use. If it is race or color, stop. No defense exists. If it is sex, religion, or national origin, go on. Race or color in the question means BFOQ does not apply. Justify. Show the characteristic is reasonably necessary to the normal operation of the business. The essence test, not the convenience test. Essence means the business cannot function otherwise. Examine. Prove a factual basis that all or substantially all of the excluded class cannot do the job. Stereotype is not evidence. Document. Show no reasonable alternative exists. If the job can be redesigned, the BFOQ fails on the 4th move. An alternative kills it on prong 4. Skip a prong. The EEOC strikes the defense. Now why the other 3 fail? Option B, customer preference. The single most common BFOQ argument employers actually try, and the single most explicitly rejected theory in Title VII case law. Diaz versus Pan Am settled this in 1971. An airline could not use customer preference for female flight attendants because preference never reaches the essence of the business. Option C, Executive Order 11246, Utilization Goals. That is affirmative action for federal contractors, a separate body of law about equal opportunity. It is not a defense to a Title VII discrimination claim. Option D, undue hardship. That is the threshold for denying a reasonable accommodation under the Americans with Disabilities Act. It belongs to the ADA, not Title VII, and has nothing to do with whether a characteristic is essential to a job. The pattern. On any BFOQ question, look for the word essence or the phrase reasonably necessary to the normal operation. If those words are not in the option, BFOQ is not the doctrine. Studying for the PHR. Here is the prep solution. PHR Complete Pass System. 1,700 plus practice questions across all 7 functional areas. 3 full-length mock exams. 600 plus flashcards. The PHR Situational Judgment Masterclass. An adaptive study calendar and searchable study notes. And your gift for staying. Use coupon code PHR10 at checkout. 10% off. prepsolution.com/exam/PHR. Practice every day. Pass with confidence.